Lady, Lord, may it please the court. We do now have a working clock. I shall be able to keep an eye on my submissions with reference to that clock. Lady, can I start with this, the core issues in paragraph 3 of the judgment, which my learned friend criticised the judge as part of his submissions.
Yep.
As I understand my learned friend's submissions in this regard, he's saying that the judge started with the wrong premise, and these should not have been viewed as the core issues. I'm at page 65 of the core bundle, my lord, paragraph, my lady, forgive me, paragraph 3 of the judgment.
Yep.
As was pointed out in the course of submissions, the judgment, of course, then goes on at paragraphs 5 and 6 to relate what the judge interpreted the parties to be saying. But it also says at paragraph 4, and there's no challenge to this, the parties agree that the answers to these two factual questions are capable of unlocking the dispute about who was responsible. And before I just take the court to part of the transcript, I do wish to emphasise little known number 1, was Felix running or walking across the road immediately prior to the collision. It's not the question of was Felix just walking or running, it's was it immediately prior to the collision, because of course the claimant's case, and the judge recorded the submissions of Miss Rodway QC at paragraph 103 on page 84, was that it would have taken about 10 seconds. Can I take the court to that, if that would assist? Paragraph 103. This was in the plausibility paragraph, as my learned friend called it. But in fact, here, the judge recorded the submissions of Miss Rodway QC for the claimant trial. By reference to the time it took for Nicholas's demonstration in the video, it would have taken about 10 seconds to get up from the floor to the point of impact. Now, as I'll take the court in respect to my cross-examination of Nicholas at trial, the evidence he gave, and may I ask, has the court had the opportunity to look at that video? That video was cross-examined upon in terms of timings, and also with reference to the evidence that he gave us to the position of Mrs. Merrett's car on the road. But unambiguously, it was the claimant's case that was a substantial period of time in which Felix was on the road, having fallen to the road, and then getting up into his crouched position. Added to that, of course, would be the time for him to get from the verge to the centre of the road. So the point about paragraph 3.1 is not simply running or walking, but it's immediately before collision. Because the claimant's case was that there was a significant gap in time in which the claimant was not walking, but was on the road, behaving in the way that the video showed. So it was a core issue, lady. Because
can I just answer the question you asked, just so that you are aware? I couldn't get it to play, actually. And I'm sure it's me, because we all received a little dongle.
Has your ladyship had a chance to look at it at all?
No, only the description of it.
May I ask, Lord Justice Bean?
Yes, I have. It's got two very short clips, one in real time and one in slow motion.
So he's walking into the
forgive
road,
me, my lady. I'm just
slipped
my
backwards,
iPad.
like, down onto
Forgive
his
me,
hands
I
and
can
knees,
stop
sort
this
of like
now.
this. And as he was getting up, sort of.
I'm happy to pass my iPad up to the court.
If you would,
if your ladyship wishes to press on that play button. There's the voice.
Yes.
Forgive me, I didn't think that would assist to bring that, but I'm glad I did.
Well, I'm glad you did, but I'm sure, as I say, it's my fault rather than the thing that was sent, the dongle that was sent.
I have to say, I had several attempts before I could access those links myself. But I think if you press the play arrow on the top left, it should start. It is downloaded onto my iPad.
Yeah, okay.
So he was walking into the road and then he slipped backwards, like down onto his hands and knees, sort of like this. And then as he was getting up, sort of crouching, and then stood up, and that's when he got hit.
Right, and then there's a slow motion version.
There is. I only downloaded, I'm afraid, that one onto my iPad, so that's the only one I can assist the court with.
I think the real-time one is more useful.
Yeah, okay.
That is the real time.
Thank you very much. And this is Nicholas. And can you remind me of the date that the video was taken?
I think it was February 2020.
Thank you.
It was the second witness statement. I'll just check that now. Thank you very much indeed. Yes, the supplemental, it was the 24th of February 2020. And that was exhibited to that witness statement.
And what I saw on the video was Nicholas demonstrating Felix falling backwards and then manoeuvring himself onto his, as it were, all fours to push himself up.
Indeed. And I described it to Nicholas in cross-examination, crabbing. It's quite difficult to we're not going to learn the crouching word, but crabbing his way back up into a standing position.
Right.
But as I'll take the court in a moment, the evidence of Nicholas was that there was a slip which was violent enough to cause Felix's left foot to go away from him, to propel him either onto his bottom or his hands, he couldn't quite remember, but to propel him into the shape that you see on the video. So backwards,
yeah.
And to fall like that.
But not sufficient, sufficient to, as it was, knock it off balance, his body off balance and down.
Yes.
So he didn't demonstrate on that video attempting to right himself. It was a fall and then a get onto the front.
Yes,
yeah.
Yes. Yeah. Without any difficulty in re-standing, as it were, apart from the time that it took. But my point with relation to the video and the evidence was that the judge was faced with this very stark position. And whether or not Felix was running or moving, walking immediately before the collision was extremely important. Because on the case was presented, he wasn't, and hadn't been for what is in a scheme of a road traffic case, a long period of time. And can I just, for your ladyship's note, just refer the court to a couple of the paragraphs in the transcripts that have been provided to the court. In this supplemental bundle, tab 22, page 220, lady, this was at the final day on the Friday the 5th of March, as I opened my closing submissions. Perhaps I could just ask the court to read the judge's query, starting on line 13 on page 1, going down to line 5 on page 2. My lady, as the court can see at line 15, I responded, Your Lordship, during the course of evidence has indicated you perceive these to be the core issues. This is part of the issue on appeal, of course. The court does not have every day of the transcript, but it was quite clear in my respectful submission by the end of the trial that the parties had agreed those to be the core issues, and you can go on to read that Miss Rodway QC, for the claimant, did not demur from that. and on the top of page 3 at line 4, simply added, there is one element within this, my lord, which is not factual, which is dependent upon both, of course, lay evidence and expert evidence, and that is the engineering evidence from Mr. Sorton that Felix must have been stationary at the point of collision. So, the engineering evidence of Mr. Sorton, which, as I said in my very brief submissions at the beginning of the day, is heavily relied on by the claimant at trial, was repeated there by Miss Rodway. And then just over the page at 221, the lady on internal page 144, Judge Hermer again posed the question, paragraph at line 8. I mean, you've both been very clear that if the factual case on either side is made out, one of you is going to lose or one of you is going to win. Miss Rodway and I both responded to that. Positive.
But this was in response to the suggestion about a contributory negligence.
It was, but it was also in the context of, as was known throughout in my respectful submission, that whoever's factual case the court found in favour of would be the victor, as it were, at trial. So if I can turn, if I may, to what the thread that seems to underlie Mr. Weir's submissions, this question of the hard evidence and the judge's failure to effectively apply that hard evidence in his judgment and to test the witness evidence against that hard evidence. Mr. Weir briefly said that there was hard evidence in terms of the damage to the vehicle. It's important, however, my lady, for the court to understand that the hard evidence, and if I can ask the court to turn to page 69 of the core bundle, which is the judge's figure 3. The hard evidence was not simply that there was an impact with the front of the car. The hard evidence, as it were, from the engineering perspective, was that there was evidence of a collision between the car and Felix, both on the front and the front offside. So the points of impact that Mr. Johnson indicated in his diagram, which the court accepted, included the points below the headlight, and then on the offside corner, extending down the wing. Now, my lady, this occupied a great deal of time at trial, and I'm sorry to flick between bundles, but if I could ask you to go back to the unagreed bundle at page 14. At paragraph 17, there was an agreement between the Reconstruction experts that the scuff marks on the offside of the defendant's vehicle indicated there was sliding contact between the claimant and the offside of the vehicle. In other words, that there was what was called at trial a wraparound, but impact on both the front and then the front offside wing. Mr. Sorton at trial tried to resile from that admission. You may well have picked up from the judgment how the judge dealt with it. But it was relevant, my lady, because, as I said in my brief submissions earlier, Mr. Sorton supported the claimant's case by saying Felix can't have been running at the time that he fell, because if he had been, he wouldn't have been displaced into the oncoming lane. So Mrs. Merrett was coming towards, and Felix ended up in the opposite lane to Mrs. Merrett, some distance away, and so he was displaced in that direction rather than in front of the car or towards the curb. And Mr. Sortland said, on a conservation of momentum argument, he can't have been running at the time because he wouldn't have gone in the direction that he did once he was in contact with the car. And he had to accept, however, at trial, that because of the contact being on the extreme front offside and the wing between Felix's body and the car, that the displacement to the offside of the car could have occurred if Felix was running. So the hard evidence in terms of the engineering evidence, as it were, was not simply that there was contact at a low point on the vehicle. There was contact on a number of points of the vehicle, including, as figure 3 indicates, on the front offside wing.
Mr. Weir this morning, though, points out that, and I don't think you indicated any disagreement, that the red spot we see over the wheel arch where there's damage, that's 60 centimetres.
It is, 2 feet.
So we're still talking about a very low level impact.
We are, depending on obviously, that's a point of contact, and that's correct, and that was 2 feet above the ground.
Yeah.
No, it doesn't come out on the diagram, but it is 60
It is 60
centimetres. I can confirm that. So, the engineering evidence, therefore, that the court had, ultimately was consistent with Felix being in a forward-running motion at the time of impact. And as I said earlier on, my lady, it was actually Mr. Sortland, the claimant's expert, who identified in June 2019, paragraph 64 of the Reconstruction joint statement, the issue to be resolved is whether the claimant was in the process of falling to the road surface in accordance with some witness evidence, or in the process of getting up following a fall in accordance with Master Stannard's description. So in terms of the hard evidence from Dr. Hulse, the test, in my respectful submission for this court, is whether the appellant claimant can establish that the judge demonstrably misunderstood the evidence of Dr. Hulse, such as to effectively, I use the word corrupt, but in the widest sense, his reasoning in the judgment. There's a lot of activities to my left, forgive me. Of course, my lady, the court, I know, doesn't need to be taken to the authorities, but I, before going any further, would ask the court to note, and perhaps just for the court's note rather than going to paragraph 57 of Lord Reed's judgment in Henderson and Foxworth, where he says, includes that paragraph, an appellate court could therefore set aside a judgment on the basis that the judge failed to give the evidence a balanced consideration only if the judge's conclusion was rationally insupportable. And I take it from what my learned friend is saying that the claimant's appeal is predicated on the basis that the judge's understanding of the evidence of Dr. Hulse is so demonstrably wrong that it makes the judgment irrational and unsupported.
Well, it's not irrational in the sense of mad, but irrational in the sense that the reasoning is so flawed that
yes,
it's unsustainable.
Indeed. No, I'm not trying to suggest irrational in that sense, my lady.
No.
So, my lady, can we consider, please, the evidence of Dr. Hulse at trial? My lady, if you turn to the supplemental bundle, and Dr. Hulse's evidence starts, give me a moment, at page 212. It actually starts at 21. Evidence in chief starts at 211. Cross-examination starts at 213. In his evidence in chief at page 212, internal page 124,
Yeah.
at the top of that, lines 1 to 7, Dr. Hulse had to correct a previous opinion which he'd given based upon there being injury to both feet. Maybe you asked a question this morning about that. Because he made a mistake, as you later admitted, in working on the basis that Felix's right leg and foot were injured when they were not. And then what might be relevant, over the page 213, page 125, internal...
So was that a matter put to Dr. Hulse on the basis of you've made a typographical error, or...
No, I'll take you to that matter.
Oh, sorry.
I got... The judge cut me off in my cross-examination of him on this, as you'll see in a moment, but only to say I've got the point, effectively. But no, it wasn't a... Dr. Hulse said it was a mistake,
Yeah.
but wasn't prepared to go any further than admitting why he'd made that mistake. But I will take you to that in a moment,
Yeah.
because I do think it's, certainly from our point of view, Melody, very important for this court to understand the evidence that he gave, which is why I'm going to focus on it in the time that I have. But I did want to make that point to start with, because Dr. Hulse's evidence, as it were, started off with him having to make an admission that he'd made a mistake in his report. He also clarified in chief at page 125, sorry, internal 125, that's page 213. He said at line 16, Miss Rodway QC, there was just one other point which I noticed going through the report, which is at one point I've said that Felix's foot was run over when he was laid on the road. I think that's probably been rather poor English. I just wanted to convey that he was relatively horizontal on his foot. I wouldn't like to suggest that he was actually lying either still or flat on the road at that point. So that was two elements of clarification in respect of his evidence. But he then, when the cross-examination starts at page 126, I took him to this question of him being wrong on referring to both feet being injured. And my lady, at this point, can I also ask the court to have open Dr. Hulse's report? It's at tab 6 of the supplemental bundle, and the section I'm going to be referring to starts at page 47.
Yeah.
Now, my lady, if the court looks at page 48, Roman numeral 4, part of Dr. Hulse's evidence to the court, as you can see there, was as both feet appeared to have been run over by the front offside wheel. It's likely that Felix's feet were close together at the time he was hit by the front of the car. Hence, it is unlikely that Felix was upright and mid-stride at the time of impact. Dr. Hulse withdrew that paragraph in cross-examination, as the court, and I'm sorry to trouble the court to have two files open at once, but if the court could have page 214 of the supplemental bundle, in front of it, at page 129, starting at line 15 on 129, I quote that paragraph to Dr. Hulse, and he withdrew it. Now, my lady, for the sake of time and sake of time of my submissions, I'm going to be asking the court, and it may well be that after submissions anyway, the court will again refresh its memory by reading all of the evidence of Dr. Hulse. But as you can see, reading on through page 130, 131 and 132, I challenged Dr. Hulse as to why that mistake was there, until the judge on page 132 effectively headed me off by saying he had the point. Now, no criticism of the judge for that, but just simply it wasn't the case that Dr. Hulse was providing the court with evidence which he didn't modify, for example, at trial. He modified that. Those are probably side issues, I accept. When it comes to the main point that was taken in cross-examination with Dr. Hulse and the evidence that he gave, can I start, my lady, by asking the court to turn to page 215 of the supplemental bundle? Internal page 136 of live note, line 18. Dr. Hulse, this is the diagram, my lady, which is in the judgment, and for the court's note, the diagram is at page 56 of the supplemental bundle, and appendix 3 of Dr. Hulse's report was entitled Diagram Showing the Likely Position of Felix Barrow Relative to the Front of the Car. Note the word likely. And again, for the court's note, at page 47 of the supplemental bundle in Dr. Hulse's report, when introducing that appendix, the diagram, he had said at paragraph 4.02, Roman numeral 1, I consider it likely that Felix was either on his hands and knees or in a crouched position close to the road surface when he was hit by the car on his left side. See appendix 3. And appendix 3 is the diagram. However, when he came to give evidence, as we can see it, internal page 136 on 215, his evidence was being taken to the diagram. Yes, in my report, what I actually say is this diagram is not meant to be descriptive. This is meant to show the relative position of Felix's head and body relative to the front, the height of the front of the car, which is, of course, not how it had been put in his original report. And I make those points because criticism is made of the judge in his judgment, where he says that the reader might be forgiven for thinking, this is at paragraph 75 of the judgment, that evidence had been preferred of the precise position of Felix. But that wasn't the case following cross-examination. I'm summarising paragraph 75, but I'm just addressing the point that was made to you by a learned friend, that somehow the evidence of Dr. Hulse was misunderstood, and the judge believed that Dr. Hulse had somehow changed his position. Well, Dr. Hulse did change his position. In his original report, he'd offered a view on the likely position of Felix. And then in the substantive cross-examination of the evidence of Dr. Hulse, the judge at paragraph 75 quotes from elements of it. And, milady, I can tell the court, and it may assist the court for the court's note, as it were, those parts of the transcript of the evidence of Dr. Hulse which contain those quotations, if that would assist the court.
Yes, please.
So, my lady, on paragraph 75 of the judgment, the first italicised quote, the court will find at internal pages 143, 144, page 217 of the transcript of the supplemental bundle. The second italicised quote is at page 218 of the supplemental bundle, internal page 145 of live note. The third quotation is at page 219, that's page 219 of supplemental bundle 151 of the live note. And the fourth quotation is at 218 of the supplemental bundle, page 148 of live note. Now, the judge could have quoted quite a lot more of the evidence of Dr. Hulse, and I intend, if I may, as quickly as I can, to take the court through this, because in my respectful submission, it shows that the judge understood full well the evidence of Dr. Hulse was and what it meant, and did not labour about under some misunderstanding in respect of it. What Dr. Hulse said, first of all, my lady, at paragraph 216 of the supplemental bundle, top of page 137, he described the pictogram, as it was called in cross-examination, the Appendix 3. It's purely there to illustrate the level which is Felix's head and body would be in front of the car to have caused the injuries that he sustained. Note head and body, not limbs, and I'm going to get onto that. So it's, as he says, the level of Felix's body. He then goes on to say, at page 137, lines 8 to 12, that diagram, it was purely to represent the height of Felix's head and body relative to the front of the car. It was never designed to show how far across the front of the car that he was when he was hit by the car. And that was repeated. And was repeated again on page 140, for example. But can I refer the court on page 140, sorry, live note at 140, to lines 6 to 9. I'm not saying this is not intended to show how far across the front of the car he is, or it's never intended to show his exact position of his limbs. It is purely to give, and the question was, you've answered then that you're not intending to show an exact position of the limbs. Correct. Because nobody can. No. There are too many imponderables variables, so what you were trying to show is the height of the pedestrian's head. And the answer was, which I certainly took to mean yes. And what else? The height of his head and body. Now, can I ask the court then to turn over the page, because this is another relevant point. Page 141 of live note, line 25, or sorry, to be fair to Dr. Hulse, I should start at line 21. He said, so based on that, I deduced that he had to have been hit by a smooth, flat surface, and that really left us with his head coming into contact with some part of the front of the car that was smooth and flat. So smooth and flat, but of course we don't know. That doesn't refer to the plane of the car, it's just talking about something that's smooth and flat in whatever plane that is in, i.e. whether it's on a corner or whether it's on a straight line. And the answer was, that's correct. So then, going over to page 143, live note, I've already told you, my lady, that the answer that the judge quotes at lines 21 on 143 to number 1 on 144 is there. I can't be prescriptive about Felix's absolute position, and you can read that. And then, just after that, line 3 on 144, so that is all you can say. So you're not saying to my lord or to the court, in fact, the position of the pictogram, there is something that on the balance of probabilities, that's the position of Felix just prior to the impact. In terms of his limbs, no. I can't say that. I've never tried to say that. The judge then quotes the answer given by Dr. Hulse at the top of live note page 145 on 218. The question that elicited that response is on page 144, the bottom of that. Would it be right to say in summary that you've agreed with Dr. Fletcher, but you can't say as a matter of medical evidence whether or not from the injuries that Felix Barrow, I don't think this is correct, no, anyway, there we are, was in a crouched position and rising at the time of the accident, or whether he was falling forwards in a stooped position at the time of the accident? And that's what prompted the answer. No, I cannot say from his injuries what his body movement was at that time, whether he was stationary, falling, getting up. There's nothing in terms of the injuries that would help. And then, as I quoted in my skeleton, at the bottom of page 145, live note, question begins on line 25. So you can't differentiate and inform the court on the balance of probabilities that Felix Barrow was in a static, crouched position rising upwards at the time of the accident, no more than on the medical evidence could it be said that Felix Barrow was falling forwards at the time of the accident. That is correct. No one can say, not on the basis of the injuries that Felix sustained. So, as the judge, having asked Dr. Hulse a question, then Dr. Hulse confirmed his evidence at lines 13 to 15 on 146. On the basis of the injuries I don't believe that we can differentiate between these two possibilities, those two possibilities, or three possibilities. He repeats his evidence in terms of he cannot say where Felix's limbs were, just simply his head and torso, so the level of them. And then the next exchange that I refer the court to is at the bottom of 146, beginning on line 24. It's a little garbled, and reading one's cross-examination is never particularly a pleasant task, my lady, but I thought it was better at the time, but it does appear to be a little garbled. But
all those half sentences.
It seemed to flow a bit more at the time, but there we are. Question, there's little difference between them, but we still have the caveat, which I think you're saying is, that either of those two, neither of them can be prescriptive about where Felix Barrow's limbs were, or his position as such. You are going on the basis of the position of his head. Yes. The only thing we can say about Felix's limbs is that his left elbow had a fracture dislocation, etc., And the judge then said yes, and the answer was that must have been caused by contact with the front of the car. Now that wasn't evidence that it was just the frontal plane of the car as such, because of course the contact evidence was with both the front of the car and the offside wing.
And that's what you follow up at
Indeed,
line 19.
Somewhere on the car that caused the fracture to the elbow and the femur, yes. And the jaw, and then the question of the jaw, we can't say where those limbs were at the time of the impact itself in relation. No. In that position, we can't say no. All we can say is he must have been in front of the car. That's all we can say. And then the judge intervened with a question on page 148, asking about the diagrams, which Dr. Hulse had put into evidence. Do you understand it from your answers to counsel that we shouldn't take this as a kind of binary decision between one or the other, that this represents an approximation of the body position? It may correspond more closely to one or more closely to the other, but we just don't know. We don't know, no. It could be either. It could be in between. It could be slightly different.
Can I just ask, Mr. Sullivan? Mr. O'Sullivan, sorry.
Sorry?
You did follow up with Dr. Hulse about the direct blow on the left side somewhere on the car that caused the fracture to the elbow and the femur. Yes. And the displacement of the knee, but that's all we can say. We can't say answer and the jaw. Question and the jaw. We can't say where those limbs were at the time of the impact itself in relation ... No, in that position we can't say no. We can't say it on the balanced probabilities either, can we? No. All we can say is that he must have been in front of the car.
Yes, so at some point he was in front of the car. Not struck by the front of the car, but obviously the car, he was in front of the car and it hit him as it was moving forward.
Okay.
And finally, again, I will then move away from Dr. Hulse. So forgive me if I've laboured it, but it is important in my respect to this mission. The judge, in his judgment, quotes a response that Dr. Hulse gave him, but in my respect for the submission, it is important for the court to understand what the judge had in fact asked Dr. Hulse. And that's at page 219 of the supplemental bundle. At page 150, live note. And perhaps I could just ask the court to read from line 12 of page 150 where it says Judge Hermer, because that then gives a context to Dr. Hulse's answer, which is at 151 between 4 and 9. So Dr. Hulse, save for saying that the head and torso of Felix had to be at a level with the contact damage on the car, couldn't be any more prescriptive than that. He couldn't say on the balance of probabilities where Felix's limbs were. And obviously it wasn't a matter for him in any event to say where on the car Felix was struck. But he did accept it could have been on any plane of the vehicle as long as that plane was smooth and flat. It wasn't the case that he suggested that it would have been anatomically impossible or anything of that nature for Felix to get into a position of falling forwards and coming into contact with the vehicle at perhaps 2 feet off the ground. All the judge had to work on from Dr. Hulse was the level of the pictograms were attempting to illustrate the level of Felix's head and torso at the point of impact. But contrary to what he'd stated in his first report, he couldn't say whether Felix was moving, stationary, falling forwards, or standing up at the time of the collision.
Are we to take anything from the fact that there is impact damage above the wheel arch?
Well, that was something which featured very heavily at trial, yes, because it was to do with the wraparound, as it were. So it wasn't the case, this wasn't a straightforward accident where there was a pedestrian on the front of the car who only collided with the centre of the bonnet and either was propelled upwards or propelled forwards. This was an extreme front offside collision. So there was part of it, and this was described by Mr. Johnson, the judge accepted that. Part of it, the damage was just around the headlight, and the rest was then around onto the wing. So there was the wheel arch, there was a displacement of a piece of material which is on the photograph. And Mr. Sorton, when it came to trial, tried to disavow his agreement in the joint.
But before we get there, and forgive me, Dr. Hulse said the front of the vehicle, the injuries were caused by impact with the front of the vehicle, which isn't a wraparound, is it?
Well, he wasn't giving evidence on that. He was just giving evidence, and as I say, that's why I asked him about the plane of the... All he could say was that it was a smooth, flat surface.
That caused each
Felix's
and every
head
one
injury.
of the...
Yes.
The head injury,
yeah.
And also the femur and the elbow.
Well, he was actually only giving evidence. The smooth, flat surface was only in respect of the head injury, but it's been assumed that the contact, obviously with the femur and the elbow, etc., were with part of the car, and all of the areas of contact, effectively, were smooth, flat surfaces.
Yeah, okay, I get that, but I'm still not quite into the wraparound. If Dr. Hulse wasn't picked up on the fact that there was impact on the side as well as around the front.
Well, he, as I said, in cross-examination, it was somewhere on the car there was that impact, and he wasn't saying it was the front of the car. So, for example, it wasn't the case that his evidence to the court, looking at the pictogram in the judgment, that the impact was only on the red dots on the front of the vehicle. If one looks at page 69, figure 3.
Yeah. Which is reproduced by the judge.
Yes.
Yeah. So it's just this, all we can say is that he must have been in front of the car.
Exactly. So...
And is that consistent then with the damage to the wheel arch?
Yes.
Okay.
Because the contact was on the extreme front corner, as that pictogram illustrates, which then, because of the movement, led to the wraparound. And as I say, that's occupied a great deal of time at trial, but it was a sliding contact, as it was described in that joint statement.
Which is referred to in the
that
report.
joint statement, yes.
Yeah, I understand now.
So the judge had the evidence of Dr. Hulse, which, by the conclusion of the cross-examination of Dr. Hulse, did not support the proposition that Dr. Hulse's view coincided entirely with the description provided by Nicholas Stannard. In other words, my lady, Appendix 3 to Dr. Hulse's report, which is the top pictogram showing the individual effectively getting ready to run a race next to the car. That's at page 79. not the case that Dr. Hulse was maintaining that that was the likely position of the claimant at the time immediately prior to action. So it was entirely open to the judge, first of all, to conclude that the medical evidence was consistent either with Felix rising up from a static crouch position or falling into a position in front of the car. And the judge, in my respectful submission, going back to the judgment on page 84 of the supplemental bundle, which is the conclusion of paragraph 99, was entitled to make the finding that he did.
Did you mean the supplemental bundle?
Oh, sorry, the core bundle, forgive me. I'm so sorry, my lady. I meant the core bundle.
Yeah.
Page 84, this is paragraph 99 of the judgment. The conclusion of that paragraph are critical to the judge's reasoning in this judgment. Beginning with equally, the equivocal nature of the medical evidence, whilst assisting in identifying Felix's likely head and torso position at the time of the impact, does not permit an expert assessment as to whether it was consistent only with a slip forward whilst running, or a return to the feet from a fall to the bottom, or some other mechanism. Well, that was a finding that was open to the judge on the evidence of Dr. Hulse. And his, as it were, a summation of the point, there is no independent objective evidence truly autonomous of the witness evidence that is capable of demonstrating that Nicholas's account of occurred must be wrong, or that Felix could not have run into the road and slipped forward a moment before impact. Again, in my respectful submission, based on the evidence that he heard from Dr. Hulse, that was a finding that was entirely open to the judge and does not demonstrate a misunderstanding of the evidence. So it wasn't the case that, for example, Dr. Hulse gave evidence that has been described by Mr. Weir, that Felix was in some sort of crouched position, because of course he was at pains to say he couldn't say where the limbs of Felix were at the point of impact, purely that the head and torso were at a level to have impacted with the car.
Can you, I'm just going on from that submission. Figure 4 in the judgment, just after paragraph 76, reproduces the pictogram, which Dr. Holt said was he drew the head and then Mr. Storen.
Well, it came out at trial and Mr. Sortland actually produced that.
Yes.
Yes.
But Dr. Holtz had done the
Approved
head.
it, yes.
Yes. I think he said he'd drawn the head.
He did it,
Yeah.
yes.
And then we get the photograph, which is showing at the position of the left arm coming forward. This is Mr. Storen's son, is that right?
Yeah, so what Mr. Sorton, whose son happened to be a very similar height, interpreted the evidence, both on contact with the car and generally, to say, well, in order for the damage to the car to be where it was, or words to that effect, Felix would have been in this position, or something like that. So it's trying to illustrate the position that the claimant would have been in as
But-
Mr. Sorton understood it.
But that wasn't taken from Dr. Holz's evidence. It wasn't Mr.
No.
Storen saying this is, I interpret Dr. Holz's evidence to be such and such.
No,
No.
no. But what then happened in the second joint statement, my lady, which you were taken to,
Yeah.
can I ask you to again pick up the supplemental bundle? At page 102 of this supplemental bundle,
Yeah.
at the very top, I think you were taken to this, there was an agreement that the main issue to be resolved from the medical evidence is whether Felix was in a crouched position and rising at the moment of the collision, or if he was falling forward, assuming a stooped position. And they reproduce, going over the page at 103, what they understood to be the two alternative hypotheses, the crouched static position and the falling forwards position below, and stated Dr. Fletcher and Dr. Holtz agree it's not possible to differentiate these hypotheses definitively on the basis of the injury sustained. So both diagrams were introduced into evidence by Dr. Holtz giving evidence, and he agreed with those propositions and very clearly set out his position in answer to my questions, but also the judge's questions at the end of his evidence. But there was a deviation from that joint statement of those positions, because in cross-examination, Dr. Holtz then also said he wasn't trying to suggest the position of the limbs. And that's important in my respectful submission.
And that was an answer to the judge
And to me.
and to you. Okay. So the judge was just following up in confirmation.
Yes. Just again for your ladyship's note, page 216, live note, page 140. I'm not saying, this is line 6, that this is not intended to show how far across the front of the car he is, but it's never intended to show his exact position of his limbs. It's purely to give you, you've answered that, you're not intending to try and show an exact position of the limbs, correct, because nobody can, no. And there are further answers to that extent as well.
Yeah. Okay. And you took us further down to the and what
Yes.
else? Yeah. Yeah. Thank you.
So, in my respectful submission, the approach the judge had to the expert evidence of Dr. Holtz was entirely open to him, bearing in mind the evidence that he'd heard from Dr. Holtz, which was that it could have been that Felix's head and torso were in the position sufficient to have contact with the vehicle, either as a result of the fall whilst running, or as a result of being in a crouched static position and rising upwards. I think what my learned friend really challenges is the notion of the claimant being able to get into that position, as it were, the falling position. And that's paragraph 113 of the judgment. might be sensible to go to that before I turn to the Alex Gent issues. I'm conscious of time as well. If we could perhaps deal with this point now, starting whilst the court is at page 86, 87 of the core bundle. Can I ask the court to note that at paragraph 110, when the judge deals with the inference that he drew in respect of the absence of any evidence of anything slippery, etc., he did state at the conclusion of that paragraph, in these circumstances it seems difficult to understand why a person walking across the road would slip in the manner described by Nicholas, which, as I'll go on to say in a moment, was a perfectly reasonable inference for him to draw. A person, to my mind, is much more likely to slip or fall or stumble when running and or when appreciating in a split second that they are in danger of colliding with an oncoming car. So it wasn't just simply the judge believing there was some form of slip. And the word slip in submissions was certainly used as a term which encompassed any number of unintended movements. He went on to say at paragraph 112, I've not overlooked an argument advanced with vigour by the claimant, namely that Felix's likely body position at the time of the impact was simply incompatible with a slip or momentary fall forward, and was equally irreconcilable with Mrs. Merrett's position of him being crouched. Furthermore, it was said that the inherent improbability of this as a satisfactory explanation is reflected by the fact that it was advanced relatively late in the day by the defendant. Now, the judge deals with that latter point in the second half of paragraph 113. But, the point about the judgment of paragraph 113 is the judge felt it was open to him, having heard all of the evidence, to conclude that there was a common sense basis, in effect, for concluding that Felix, the most likely version of events was that Felix stumbled or fell forward as he was running across the road and fell into a position where his head and torso were at the level of the car in order to impact with the car something in the region of 2 feet or less above the ground. And for this judgment to be set aside is effectively what's being advocated for by my learned friend. My respectful submission, the court would have to conclude that it wasn't open to the judge to reach that conclusion. Which, of course, I would strongly take issue with, because it was. And what my learned friend's submissions also ignore is that this forensic process was about the assessment of Nicholas Stannard's evidence and the Stannard hypothesis, as we called it at trial, of Felix standing carefully by the side of the road, watching in his witness statement in 2018, he said that there were 2 vehicles passed from his right. At trial, and I'll go on to this in a second, he said it was 1, but the hypothesis was that there was traffic which passed from Felix's right. He waited. It was perfectly safe to cross the road. The vehicles towards the northern crossroads, as we call them, where Mr. Gent came from was the northern crossroads at Mislingford Road. That was 250 metres away, and Mrs. Merrett was coming from a crossroads that was 480 metres away. And what Nicholas said at trial was that the car passed in front of Felix, it was all perfectly safe, the vehicles from the right were up by those crossroads, and Mrs. Merrett was down by the other crossroads. So a considerable distance away. And that Felix then crossed in perfect safety, but then the events occurred, as shown on the video. And so he was in the road for a very considerable period of time. So what the judge was faced with was having to determine whether or not he could accept that evidence. And the evidence of Dr. Hulse didn't compel him to accept that evidence or in any way lead him down that route, because of course the evidence of Dr. Hulse was the medical analysis of the injuries doesn't indicate one way or the other on the balance of probabilities that Felix was static and rising, or whether he was falling forward. The only point was, it was the height at which the height on the car at which the injuries occurred. So the judge had to analyse Nicholas Stannard's evidence independently and consider it against the other evidence. Now, the two main reasons, of course, that he did not accept the evidence of Nick Stannard were Mr. Gent and the PC Giles log report. Now, can I start with, therefore, with PC Gent? PC Gent, I've fallen into my own friend's trap. Mr. Gent, and as I said a moment ago, the critical point of his evidence was that there was no gap between Felix, no appreciable gap between Felix running out into the road and being hit. So it was a continuum rather than something where there was a very significant break in time. Now, my learned friend this morning in submissions referred you to the police log of the 7th of October in respect of Mr. Gent, which is obviously a hearsay statement. What you weren't referred to, but is in my skeleton, is a very important document which the judge placed great reliance on in my respectful submission, which is the witness statement that Mr. Gent gave to the police the day after the accident. And that is at page 22 of the supplemental bundle. If there is a formal time frame for me to conclude, my lady, I'm afraid I'm not aware of it. I'm just wondering what leeway you would give. Half an hour, perhaps?
I think that Mr. Weir needs about half an hour, so half an hour more.
That should be fine, my lady. I will get through my submissions.
Yeah, I'm sorry I've intervened, because that would have...
No, my lady. I'm here to assist the court.
Well, as I said to Mr. Weir, it's sometimes we have to challenge in order to understand.
I fully accept that, my lady.
Yeah, okay.
And I'm here to assist.
Okay. Well, so was Mr. Weir.
Indeed he was. Indeed he was.
So, yes, so this is the statement that was taken by PC Giles the following day.
Indeed, and this was adduced into evidence by Mr. Gent at trial. And in his evidence, he said that effectively this was his statement. It wasn't a question and answer session. And if we could look at this, please, because it is a very important document. He says he left his home address, etc. My route took me from my home address onto Gravel Hill. Slightly confused. Hill Pound, my lady, becomes Gravel Hill. So Gravel Hill is the road we're talking about.
Yeah.
And then generally down towards Wickham, I was driving my blue-grey Renault Clio. I turned left onto the road and had the houses on my left-hand side and fields on my right-hand side. My lady, in case you, after this, find any use doing a Google search on this and a street map, you'll see that it's all now built up on the right-hand side, but at the time there were fields. There was a grey large saloon around 3 lorry lengths ahead of me, I would estimate 50 metres. I'd only just pulled out of the junction and was still increasing my speed. As I was travelling along the road, I saw a boy crossed out to child in dark school uniform on the right-hand side, stood on the pavement. That's Nicholas, on the pavement. As the grey car ahead of me passed the driveway, I saw a boy run from the left of the road and out towards the middle. I then saw a small Toyota Yaris, which was red, appear from behind the grey car, travelling towards me. The boy ran straight out into the path of the red car. There was nothing the red car could have done to avoid hitting him. The red car obviously braked as the front went down and the driver steered to the left. It looked like the car almost hit the curb. The boy bounced off the front driver's side corner of the car and was spun around before hitting the road. He did not go under the wheels of the car. So when Mr. Gent came to give his contemporaneous witness statement, he described the boy bouncing off the front driver's side corner of the car, which is correct in my respectful submission, and was spun around before hitting the road. He did not go under the wheels of the car. Well, that's correct because the claimant was displaced to the offside. And of course, one hesitates to be talking about things like this, but he wasn't driven over, as it were, as sometimes happened in these accidents, by pedestrians who were propelled forwards of the car.
Mm. And there's nothing in this statement that suggests he bounced over the bonnet.
No.
So Mr. Weir was pointing out that what sauce for the goose is sauce for the gander, when he does suggest that he bounced over the bonnet, that's an inconsistency.
Well, it's a hearsay statement the day before because it's not signed. Obviously, then I accept that Mr. Gent subsequently then, in his civil statement, didn't quite use those words. Didn't say bounce over the bonnet.
Sorry, it's my words. Yeah.
Folded over on.
Folded,
over.
yes. Now, of course, there's no damage to the bonnet.
No.
But the judicial leeway given to Mr. Gent was on the basis that what he saw occurred in a split second, which was entirely open to the judge, because if he accepted Mr. Gent's basic or core evidence, which was that he was behind the grey car passed a boy, and a boy ran out from the side of the road and into a collision with the Toyota, then this would have all occurred in a very short time frame. A very short time frame. Now, Mr. Gent was challenged at trial, my lady. He was cross-examined, and if I can take you to that, I do want to take you to a couple of bits of it, which are important. Can I ask you to turn to page 207 of the supplemental bundle? What's being suggested in this appeal is that there was an evidence base for the court to have concluded that, in fact, the grey car was driving towards Felix as Felix was crossing the road and or in the road. In other words, Mr. Gent didn't have a clear view of events ahead because the grey car was blocking his view. I'm going to deal with that in a moment, but can I ask you, my lady, to look at live note page 102. The question, that's line 6, Miss Rodway. Well, let me be very clear. What I'm putting to you is the possibility that you didn't in fact see the whole thing, because this was a child who was moving in front of the grey car and not behind it. So he wasn't directly, and Mr. Gent immediately answered no, because the grey car was ahead of me, so he ran behind the grey car in order for me to see him. And then the next answer, he gave obviously the evidence about the hedge and then the claimant running out. And then the next answer, yes, he ran across yes. And he gave an answer at the top of page 103 as to why he hadn't done anything to warn other traffic. Because I was far enough back not to cause a hazard to myself, and it was too late by the time there was no point flashing a warning if someone is halfway across the road. So there was no time or no need for him to do anything. But he was adamant in cross-examination, as you can see it, line 15 to 18 on live note 105 on 208, that the claimant ran from the driveway. I did not see him before. I did not see him standing by the road. I did not see him. He came out of the driveway with speed. So Mr. Gent was clear in his evidence that he was following the grey car and the boy ran out from behind the grey car. And the judge noted that in paragraph 70 of the judgment. So I suppose, my lady, technically the issue becomes, was there a basis for the judge to make the factual finding he made at paragraph 105 of the judgment that Mr. Gent clearly had an excellent angle in which to observe both Felix running into the road and the collision with Mrs. Merrett. That's the finding he made. Now, the only basis on which it's put that Mr. Gent did not have a sufficient view of what was ahead was because the grey car was between him and Felix. Well, my lady, not only did Mr. Gent disavow that, but the evidence of Nicholas Stannard was that there was a car ahead of two cars. The car that was ahead of the two cars passed, Felix let it pass, and the other cars were a long way up at the crossroads, so there was nothing there. And it somehow suggested in the appeal that Nicholas wasn't aware of the grey car passing Felix. But if the court considers that for a moment, and I think it's a point Lord Justice Bean may have had in mind, the grey car, if it's ahead of Mr. Gent and Felix is ahead of it, is faced with a child running across the road in front of it, but also falling backwards in the manner described in the Stannard video. Now, Felix was about 147 in height. It's pretty much his entire height going backwards. The accident occurred somewhere in the centre of the road, maybe probably into Mrs. Merrett's lane, a little bit. This fall would have taken him backwards into the southbound lane. There's no evidence, and it wasn't put to Mr. Gent, that the grey car braked, swerved, slowed, in any shape or form at all. And yet the judge is supposed to be criticised for failing to accept an argument which, in my respectful submission, has no credible basis at all. It doesn't accord with the evidence of Nicholas. So the claimant is effectively trying to cherry pick from the evidence of Nicholas. It doesn't accord with the evidence of Mr. Gent. And it doesn't accord with common sense either. Now, reference is made to Mr. Hardacre, and I don't know that I'm probably at the time to go to that witness statement, but the court may well have a look at it, which was a hearsay statement, who referred to the fact that when he had not even reached the 30-mile-an-hour zone, which is 80 metres away from the accident site, following a couple of cars lengths behind a car which itself was a couple of cars behind Mrs. Merrett, a vehicle came forwards flashing. Now, he couldn't say whether Mrs. Merrett could have seen that. But he certainly can't say that that vehicle had driven, as it were, towards Felix and was flashing because Felix was in the middle of the road at that time. That just doesn't stack up logically. Similarly, Mr. Gent was not challenged that he was some 3 lorry lengths or 50 metres or so behind the grey car. Now, in this scenario that's being posited of him following the grey car, it's very difficult to understand at what point Felix could have come out and been in the road if the grey car is between Mr. Gent and Felix. Because one thing Mr. Gent did say was that he did not have to take any emergency action to avoid Felix. Now, Felix was sadly, was displaced into his lane as a result of the collision with Mrs. Merrett's Toyota. But Mr. Gent told the court he didn't have to take any emergency action.
So you were saying that, I'm sorry to describe this, he was saying that Felix effectively was displaced behind him.
No, he was saying that Felix, as he was driving towards the Toyota,
yeah.
Felix was displaced towards him into his lane, but he didn't have to stop.
Right.
He didn't have to take any emergency action to stop that.
So it's no emergency action?
No emergency action. So he didn't have to take any emergency braking or anything like that. So he stopped.
So he was still approaching the scene of the collision?
Yeah.
Right. So he stopped.
Yeah.
He didn't avoid.
Yeah, he stopped in advance of it. And, but I do specifically again refer the court to the fact that it was Nicholas's evidence that the car that had passed safely, the other traffic, whether it was Mr. Gent or another vehicle, the court was entitled to assume it was just Mr. Gent, was a very long way away, up by the crossroads. And Mrs. Merrett was an even further distance away at the southern crossroads. And Nicholas accepted in cross-examination that if Felix set off when Mrs. Merrett was down towards the southern crossroads, then the time frame involved with him crossing the road and falling over was the one that it took Mrs. Merrett to drive all the way from that crossroads to the accident site, which could have been 15, it could have been 20 seconds. We can all do the sort of time and motion studies knowing that 30 miles an hour is 13.41 metres a second and 40 is 17.22. But the fact remains that the evidence of Nicholas was that the road was perfectly safe for Felix to cross. And he did not give evidence to the court, which in any shape or form could be remotely interpreted as being that when Felix was crossing the road or was falling, another car in the same lane which Felix had crossed drove past Felix. Milady, the evidence, by the way, to assist on this, of the width of the lane was it was 2.56 metres wide. So the notion, frankly, that a large grey saloon in a lane that wide would somehow, with a child ahead of it falling backwards into its lane, do nothing, not brake, not deviate, not swerve, not sound its horn, not slow down at all, but would actually just drive past, is extremely difficult to comprehend. The fact that the judge might not have referred to the argument is in no way a factor which undermines his approach, as the decision of Lord Justice Lewison in Fadje makes out. The trial court is not required to record every submission made by counsel or arguments made. Lady, would you like the reference for that?
We do in your skeleton argument.
I think it is, but in any event, my lady, it's at...
I think it's in your concluding paragraph,
yes.
Isn't it, that you quote from it?
Yes, but it's page 172 of the bundle 115, or paragraph 115.
Yeah, thank you.
So, the final piece of the jigsaw, my lady, which the judge relied upon very heavily, was the PC Giles log. Now, this was obviously a forensic process whereby the court had to consider whether or not it accepted Nick Starr's evidence that Felix walked across the road, fell for reasons that couldn't be identified, why a walking 11-year-old would slip so violently as to lose his footing and end up in that position. Nick Starr, as he gave evidence, couldn't identify any slippery substance on the road. Why, whether or not that occurred, and to consider all of the evidence in relation to it, rather than, as I think my learned friends are indicating, starting from the point of view that its evidence is supported by Dr. Hulse, and then seeing whether or not it can be undermined from that direction, i.e. the direction of travel. Now, the judge's approach to it, which is entirely familiar to most personal injury practitioners, was to make some findings, but then obviously to say, well, I don't have to determine that Felix is lying or being deliberately untruthful. I don't think he is. And my lady, the court will be familiar. That is an approach taken by trial judges very frequently in this sort of case to resolve these disputes. The judge wasn't required to find that Nicholas was telling an untruth. He was entitled to find that the words recorded by PC Giles were provided by Nicholas. Now, it's important to bear in mind, my lady, that the evidence from Nick Stannard in respect of the witness evidence, in respect of that conversation, and can I take you to his witness statement, my lady? His first witness statement is a substantive one. In the supplemental bundle, it starts at page 70. Just for the court's note, on paragraph 18 of page 72, he said that there were two cars coming from his right. There were two cars coming from his right, so he waited to let them pass and then began to cross the road. And it said at paragraph 19 there was plenty of time for Felix to cross the road. But the conversation with PC Giles at paragraph 32 on page 74, after the accident I spoke to a police officer. He asked me for my name and address, which I gave him. He did not ask me any questions about what had happened, and I didn't give him any formal statement. I didn't give any formal statement to him or speak to him about the accident. So that was the position prior to cross-examination and prior to the trial, that there was in fact no conversation between Nicholas and PC Giles. And if you just forgive me a moment, and Mrs. Stannard's evidence, which is at page 66, witness evidence, was that paragraph 26, Nick did not speak to the police officer until I was present. The only conversation Nick had with the police officer was to confirm his name. The police officer asked Nick whether Felix was running, and Nick said no. He was not asked to describe what happened. Conversation Nick had with the police officer was very short. So there was a very dramatic difference in the evidence in respect of the log. PC Giles was extensively cross-examined on it. Cross-examination of him went on for several hours. I think the judge was probably putting it rather pithily in his judgment when he said that PC Giles was having none of it. But he was cross-examined repeatedly about the log, and his essential position was consistent, which is, I only need a brief statement from the witness. It's not a Section 9 statement, it's not going to be used in a prosecution, but I need to understand what happened. and I did not ask any leading questions, and I don't ask any leading questions. But he also said that he remembered this conversation. He remembered speaking to Nick. So the judge was confronted with a position whereby it was said that Nick had not spoken to PC Giles and no one had provided him with the information that was in the log. And yet, if one looks at the cross-examination of Nick, and I probably haven't got time to take you to it now, my lady, but it was accepted by Nick in evidence. If we can look very briefly at page 7 in the supplemental bundle. That PC Giles had information that was correct, that could only have come with someone with knowledge of Nick and or Felix's movements. It was correct that Nick left the house, Denver Maru as it's called, with Felix. It was correct that they crossed the road. It was correct that Felix forgot something, so went back to the home address. It was correct that he came back to the road. So those factors were correct, but of course what was important about Nicholas's cross-examination was him volunteering and admitting that he had given Felix a warning.
Before we get to that, did Nick make a Section 9 statement?
No.
No.
No. And what my learned friend kept on referring to, as it were, Nick's statement or the information provided in November 2015, that was, of course, hearsay from the claimant's grandfather being provided to PC Giles about what Nick was saying. But no, PC Giles explained why he didn't take Section 9 statements, because the information that he had, and there were other witnesses, there were other statements, made him conclude there wasn't any prospect of success of a prosecution, so he didn't therefore follow it up with Section 9 statements. That was the gravamen of his evidence. But of course, if it was the case, not only there having been a denial of this conversation at all, that the recording of "wait, there's a car" was confirmed by Nicholas in evidence, then it meant that every ingredient of it was confirmed.
Wait, there's a car may have been. That's the green. That's the grey car. Before the grey car.
Indeed, it may well.
I mean, it's not that that's important to your case. It's the last.
Indeed, it is line. But forensically, when Nicholas admitted in cross-examination that he had given a warning, now what car that is, but there being a witness statement saying, I didn't speak to the police officer, I didn't give him a statement, I didn't speak to him about this. For the judge to resolve this dispute, he had to make a finding as to what was said and whether or not this was an accurate log. And he was entitled to do so. And of course, as my Lord Justice Bean just makes the comment there, it is the next bit, then ran across the road, slipped and hit car. So the judge was entitled to find that PC Giles was told by Nick on the day that Felix had run across the road, slipped and hit a car, Now, my learned friend says that's consistent with his case. Well, we say it's barely consistent with his case because it's missing a vitally important point, which is slipped, fell over, trying to get up, and then hit by a car. But it's entirely consistent with the alternative position that the defendant advanced. Now, my lady, bearing in mind I've just got 2 or 3 minutes left, can I just say it was fully accepted by me in closing submissions to the judge that Alex Gent did not say in evidence that he saw Felix falling forwards at the immediate moment prior to the impact. and my position then, and which the judge accepted, and which he was entitled to accept, was on the basis that Alex Gent is correct, that Felix ran across the road from the driveway and into collision with the Toyota. That was a very short time frame, and he could be forgiven for not seeing a fall immediately before the impact. But he does describe, as I say in his Section 9 statement to the police, the collision with the front driver's side, that Felix is propelled away from the car, and he described him spinning around, which would also fit with him being displaced. So yes, there was a lacuna in his evidence to that regard, but not a fatal one. And Mrs. Merrett's evidence, my learned friend, criticises the judgment, treatment of her. But I would ask the court to note the actual record from PC Wheeler of her discussing the matter with Mrs. Merrett on the day of the accident, of the morning of the accident. It's at page 61 and 62 of the supplementary bundle. The learned friend took you to this.
Yes.
But there was an emphasis I wanted to make, which I made to the judge. Then from nowhere, boy appeared from behind dark car, running to other side of road from offside gravel hill. States she felt the boy hit the front offside, which is all an interesting word, that she felt the boy hit the front offside, rather than saying the boy ran into the front offside, or I saw him do that. And in her evidence...
But she also said she drove over him.
Well, she did, which she didn't. But it's... I accept that traumatised drivers can obviously have a misunderstanding, but she was, from the very word go, saying he appeared from behind the dark car. And she did say, when she was giving evidence and when she was cross-examined, she did seek to try and explain what she meant by the word crash. And my lady, the reference for your note is page 202 of the supplemental bundle. My lady, you'll see there are some live notes evidence in respect of her, what she told Miss Rodway in cross-examination. But she was always clear that the claimant appeared from behind the dark car. And the judge, having accepted Alex Gent's evidence, was entitled to conclude, certainly on the plausibility arguments, that it was improbable that both he and Mrs. Merrett missed, this was a very long straight road with no other traffic, missed events which took maybe 10 seconds or more with the child in the road. Similarly, the judge was entitled to conclude that the reason for Felix falling in the way that he did was never satisfactorily explained. He was walking wearing solid, sensible rubber-soled boots on a surface which was described as damp, with no evidence of anything being slippery. And yet he was propelled in such a way that his feet went from underneath him and he went backwards, either landing on his bottom or onto his hands.
Well, Nick did say that there was a shiny patch on the road.
Yes, but then when he gave evidence, he couldn't say that there was anything slippery.
No. But just to detain you for a moment, I mean, on both cases, Felix slipped, whether forwards or backwards.
Well, slipped, stumbled or fell on the defendant's case. It wasn't being said that he slipped. I mean, that was, I said, used as a portmanteau term, as it were. Which is why the judge, I took the court to that point at paragraph 110,
Yeah.
person to my mind is much more likely to slip or fall or stumble when running.
Yeah.
And I think it's in the excerpt of the transcript, I do say to the judge, I'm going to use the word slip, but I do mean slip, stumble, or fall in some way. I think I've used up my time.
You've referred us to Mrs. Merrett's evidence. Would you accept that what defendant drivers say on the day, unless it's in the nature of an admission of fault, has to be heavily discounted for the fact that people who've been involved in this sort of tragedy naturally reconstruct events in a way which is self-exculpatory?
I do, my lord, and I think it was perhaps your lordship's question earlier on my lady's to my learned friend, that one can read the judgment, paragraph 104, from the judge saying that absent Mr. Gent, this probably would have been a very different outcome. And I fully accept that, my lord, that Mr. Gent was critical to our case, as was the PC Giles law. So, my lady, I've probably not dealt with everything I've intended to, but I hope I've been able to assist the court. Can I assist you any further?
Is there anything desperate that you haven't?
No, I don't think
wanted
there is.
to say and haven't?
I don't think so.
I'll just have a check. So I'm sure we can plan you a few minutes.
No, my lady.
Elisabeth. Thank you very much. Thank you, Mr. O'Sullivan.
Thank you, my lady.
Mr. Weir.
Well, please, Your Ladyship, can I start with the learned friend's response to our case in relation to there being hard evidence and of the need to test the witness evidence against the hard evidence. In relation to is there hard evidence, I'm going to seek to show that there has been no substantive challenge at all to our case that there is hard evidence in any material respect, despite you being taken through the transcript of the cross-examination of Dr. Howell at some length, as I anticipated would happen. The Ladyship may have wondered why I was doing that, and to answer something that to me didn't matter, but because I anticipated this would be where my learned friend would seek to go. And there have been no submissions at all in relation to the judge wrongly failing to apply the hard evidence in order to test the witness evidence of fact. So starting with what is the hard evidence, Your Ladyship has in our skeleton argument a paragraph that I said should not be in issue between the parties in relation to what it is that Dr. Pulse was saying. And that's page 20 of the core bundle. I invite you to go back to that, please. Paragraph 16. I'm going to endeavour to seek to show in short order that that was an accurate summation of the evidence of Dr. Hulse, and that nothing that's been said by my learned friend changes that. The closest my learned friend gets to seeking to change what's set out there comes to two issues. One, the impact being with the front of the car, and two, possibly, if I understood my learned friend's evidence correctly, possibly his taking issue with Dr. Hulse's evidence that the car drove over the left foot. So there I looked at my learned friend to see whether he really is taking issue with Dr. Hulse's evidence that the car drove over the left foot.
No.
No, I didn't think he was. His cross-examination in relation to that was simply to emphasise to Dr. Hulse that he'd made a mistake in referencing the right foot at the time, as well as the left foot, but I didn't understand him really to be suggesting that Dr. Hulse was in any way resiling from his evidence that the left foot had been driven over. So that which is set out at paragraph 16, A through to E, is the evidence of Dr. Hulse. It's always been the evidence of Dr. Hulse, and as it happens, it's not changed. And I just seek in fairly short order to make that good, if I may. Can I start by reference the order of play in which my learned friend took matters? He referenced the engineering evidence, that is something of a side wind. It's a side wind because I'm seeking to appeal the judgment, and the judge had no regard in substance, other than the record of damage to the car, to the evidence of the reconstruction experts. And you see that in the plainest of terms if you go to the judgment at paragraphs 114 and 115. That's page 87 of the core bundle. Para 114, first sentence, is set out above, been able to reach these primary findings without direct assistance of the evidence of the reconstruction experts. I won't read out the rest of 114. And 115, that's why you get the judge saying it's not necessary to determine which of the analysis of the experts I prefer, because neither contend the conclusions I've drawn from the evidence and primary facts being compatible. And then he says he's preferred the evidence of Dr. Johnson generally to that of Mr. Sawson, etc. But the evidence of the reconstruction experts didn't, save for the damage to the car, didn't materially assist the judge, and that's why I've never addressed it. That's why we were totally neutral as to whether the court really wanted a whole new joint statement from the accident reconstruction experts in the bundle, etc. It seemed to us to take matters further forward, but that was a matter of my learned friend in the court. In relation to the only issue on which my learned friend is seeking to promote something different from that which we've set out, that was in relation to was the damage to the parts of the claimant's body caused by damage from direct impact with the front of the car, or could it have been direct impact with the side of the car? And here, if you can kindly go back to the passages that the learned friend has already properly taken you to, but I just wish to go back to them to draw out the evidence that's been given by Dr. Hulse in his evidence in court. If you kindly go back to page 218, so that's supplemental bundle, page 218. And in the right-hand column, pages 147 and 148. And I'm just going to pick up at line 5 of page 147, if I may. The only thing we can say about Felix's limbs is that his left elbow had a fractured dislocation of his left elbow, and that was almost certainly caused by contact with the front of the car. And he had a transverse fracture of the left femur, left thigh, mid-femur, and that fracture is caused by a direct blow. Yes, that must have been caused by contact with the front of the car. And in fact, the jaw was directly damaged. It's my fault in answer to my lady led Justice Macur this morning in relation to, he did give evidence that you can get referred fractures, but he then actually said it's my fault. It's page, sorry, dipped out, page 215, SB 215, just 3 pages earlier. Page 135, lines 22 to 23. If your ladyship can see that. But
yeah, I've made a note.
thank you. That's when he says really to break that, and it means that part of the jaw, you have to have had a direct blow to some part of the jaw. So it was my fault, I misrecollected. He did talk about you can get transfer fractures, but he then says it has to be a direct blow to the jaw. And so he then says, if you go back to page 218, page 147 at the end, and the jaw, question and the jaw, we can't say where those limbs were at the time of the impact itself in relation to. No, in that position we can't say. We can't say on the balance probabilities either, can we? No, all we can say is he must have been in front of the car. So what we've got is very clear evidence that he's giving that there has been damage to various parts of the claimant as a result of contact with the front of the car. Go back, if you kindly will, to page 217. This is SB 217. SB 217, page 141, so top left-hand section, line 13. And that left me then with contact with the front of the car. And then there follows this section in which he accepts that that's a smooth, flat surface because there isn't a cut. That's why. There's no cut to the head. And then my learned friend says so smooth and flat, but of course we don't know. That doesn't refer to the plane of the car. It's just talking about something that's smooth and flat in whatever plane that is. That's in. That's correct. It has to be something that didn't have any sharp edges or protrusions that would have caused any wounds. So that's not different from him saying it's the front of the car part that's flat. And then that's followed up, as we see, by the passages I've taken you to on the next page, by him emphatically setting out that that is damage to the front of the car. There's a strike on those various parts of his bodies with the front of the car. And then it said, well, he did change his evidence because he never, he changed his evidence because he recognised in cross-examination he couldn't describe the exact position of the limbs. And you were taken to page 216, so SB 216, and that was page 140, line 7. And that's where Dr. Hulls actually said, no, I'm not saying it's not intended to show how far across the front of the car is, or it's never intended to show his exact position of his limbs. And the reason Dr. Hulls says it was never intended to show his exact position of the limbs is because, contrary to the submissions of my own friend, this is exactly what Dr. Hulls had said in the first joint statement. So if you go back to page 86, I took you to a passage at the bottom below the second hole punch. This is page 86, in which Dr. Hulls said, Dr. Hulls considers in the balanced probabilities Felix was on his hands and knees or in a crouched position at the time of impact. The diagram attached to his report is to show the general position of the height of Felix's head and torso relative to the front of the car. This diagram is not intended to suggest the exact position of Felix's limbs. That was his evidence back in the day of the first joint statement. It hasn't changed. Suggestion something dramatic has happened, I'm afraid, simply isn't borne out. Now, of course, and this isn't facetious, but his arm is attached to his body. There's only damage low down on the car. He has to have his head down. He has to be in this crouched position. All he's saying, if you look at the two, the diagram and the photograph, which we've got, which we can conveniently see in the judgment, and I think it's around paragraph 76. So it's page 79. All he's saying is that he can't track precisely where in an arc the left arm is. But it's not to say that it can be anywhere, because it can't be high up, or there'd be damage to another part of the car that hasn't been damaged. All of the damage has occurred by a strike. I've taken you to that page where he says that elbow is as a result of a direct strike from the front of the car. So he's simply saying, if you look, for instance, at figure 4 against the diagram, in figure 4 you see the left arm down, and in the diagram you see it horizontal. And he's just saying it's somewhere in that arc. That's all he's saying. He can't be prescriptive, he's being very fair. But what we know is his left foot is driven over, his head is right down there, his whole body is right down there, no part of his body is up. All of this damage, the head, the jaw, the left elbow, the femur, the tibia, is all caused in this small, low-down area of the car. That's what he's saying. So one gains nothing by reference to the fact that the accident occurred at or around the front offside. We've just got the evidence that the judge has assessed by reference to figure 3, I think it is, of where the damage is, and we've got the uncontroverted evidence of Dr. Hulls that has all occurred as a result of a direct strike with the front of the car. So, no part of Dr. Hulse's evidence that we've sought to summarise at paragraph 16 has been challenged. That is his evidence. It was his uncontroverted evidence. It forms hard evidence that there was a direct strike, not a sliding contact, because it's a strike with the front of the car, much as you'd expect. I'm not sure how a sliding contact with the side of a car as it goes past you is going to fracture parts of your body, but that's not the evidence of Dr. Hulse. His evidence I've taken you to is direct strike with the front of the car. So that first hour was really, respectfully, a forensic attempt to obscure or obfuscate from the reality of that hard evidence by reference to that which is said to have been achieved during the process of cross-examination. Not, as I've already submitted, that any of that really matters anyway, because how we got there isn't what counts. What counts, although in fact Dr. Hulse hasn't changed his evidence, but what counts is that Dr. Hulse's evidence is uncontroverted. The defendant elected not to call Dr. Fletcher. That was the evidence. That was hard, factual evidence, what it amounts to for the court. And nowhere have I heard submissions in reply. I don't find it in the written skeleton arguments, where I took you briefly by reference to paragraph 52 of their skeleton argument. There's one paragraph that goes through at some considerable length Dr. Hulse's evidence, much as we've heard today, but nowhere is there a challenge of substance that I've heard, to which I therefore am better placed to respond to now, that's not hard evidence that should be applied. That somehow I've misdescribed the appropriate approach to the assessment of factual evidence where there is hard, uncontroverted evidence. No suggestion I've misdescribed the appropriate approach by reference to the evidence or the judgment in Martin and the recommendations in an essay of Lord Bingham. There's no analysis, there's no facing up to the case that I seek to promote in relation to the evidence of Nicholas in November 2015. The closest my learned friend gets to it is to throw in, right at the end of his submissions, that of course is second-hand evidence, and so it is, but as I say, there has been no challenge to that being the evidence that Nicholas gave Mr. Barrow. It was never said, you didn't give that evidence in November 15. Sorry, my lord, if that's...
Well, no, he did, but that doesn't mean to say that it's incontrovertible.
My lord, is that the evidence of Nicholas in November 2015?
Yeah.
My lord, I use the word incontrovertible for the hard evidence. I don't use the word incontrovertible for the witness evidence of fact, because of course the judge has to make an assessment of the quality and reliability of the witness evidence of fact. So I don't seek to make an assessment that's incontrovertible, but I do seek to say that it was not an issue between the parties, that is evidence that Nicholas gave Mr. Barrow. That's all I'm saying. That's all. In other words, that the defendant and the court was faced with the reality that was evidence that Nicholas gave within 2 months of the accident.
Well, Mr. Weir, you keep calling it evidence, but in fact what it amounts to is a report of a statement that was said to have been made. I'm not sure it's quite right to call that evidence, is it?
Well, it's all evidence. It may be hearsay, and we've recognised that in our skeleton argument. I don't think it is any way less evidence for being hearsay. And it's not been challenged. If it was challenged, then no doubt there could have been issues.
You say it's not been challenged. What you mean by that, isn't it, is that nobody suggested that Nicholas didn't say that to his grandfather. But I mean, how could the defendant challenge that?
By exactly that way, my lady.
Exactly
you
what way?
You didn't say that to the grandfather.
But there's no basis on which. All right.
I think, Mr. Weir, that you rely upon it as hearsay evidence, that is, truth of what was said to have been said, rather than not hearsay on the basis that it was undoubtedly said. Whether or not it's true or not, it was undoubtedly said to the grandfather who faithfully reported it to PC Giles.
Yes, it's a latter for these purposes.
Yeah, so that's not hearsay, because you're only saying it was said to the grandfather. It's only hearsay if what you rely upon is the truth of the statement that is reported. So I think that's what we were trying to ask.
That's probably
That's the only thing we were trying to get to.
That's very helpful, thank you.
So is it...
It's a two-stage affair,
Yeah.
but for these, the first stage is
Yeah.
that it is not hearsay, but it is an accurate description
Of what happened.
what Nicholas told Mr. Barrow. That is not challenged, as
Right.
I have always
Yeah.
understood the
Yeah.
position. In other words, the court is, when looking at consistency of evidence and guessman issues and evidence given near to the time, as opposed to evidence adduced years later from an accident when someone's had too much time to cogitate on matters and so forth. This is evidence that was given
In 2015.
in November 2015, within 2 months of the accident. One then turns to the issue the court has to make an assessment as to the reliability of that evidence when you weigh it up against the competing evidence. And our primary submission is that when undertaking that task, it is invaluable for the court, following the guidance that I've referred to assess the contested evidence or the truth of the evidence against any uncontroverted evidence. And the point here is that that is evidence A, given long ago in November 15 and shortly after the accident, and B, long before the emergence of the hard evidence in this case. In other words, it's not, open inverted commas, a stitch-up, if you see what I mean. It's not just, well, now I've read a joint report from the accident reconstruction, I can actually confirm he's in the very position that I can see in a diagram at Appendix 4 or whatever. That's not the evidence at all. It is evidence that he gave very shortly after the accident. As I say, that's when he gave it to Hugh Barrow, no doubt on request, as in, tell me what happened, because it was all triggered by Hugh Barrow being told by PC Giles that Mrs. Merrett described the claimant as running out. That's what triggered all of that. And that was not analysed by the court. And all my learned friend says is, well, maybe one can start from November 15, but why should you? Why not start with the evidence of PC Giles, of PC Giles? To which I rehearsed the submission. Well, actually, you've got to start, like Lord Bingham recommends, you should start with what you can test, and that will inform your assessment when you then go back to PC Giles. And we're left in a situation where my learned friend says, I think I have this accurately quoted, albeit when referring to Mrs. Merrett's evidence, I accept that traumatised drivers can have a misunderstanding, but not apparently Nicholas, aged 11, within an hour of the accident, in the shortest of notes from PC Giles. That just is not a fair and even-handed approach. And when you identify the other issues which we've sought to go through, and I won't rehearse, you see, unfortunately, that this is of a piece with the approach of the court. So far as concerned Mr. Gent's evidence, I've taken the court to the inconsistency, frank inconsistency between his description of going over the bonnet and what we know to be the uncontroverted evidence. You're also properly taken to his witness evidence today following the accident at SB 23, in which I would simply ask the court to note, again, he does not describe the claimant collapsing, falling forwards, falling into a crouch position, falling almost to the ground, which is what it is. It has to be falling in a crouched way, almost to the ground, when hit by the car. He simply describes running across into the car. PC Giles did base his evidence on his having refreshed his memory. We see the exchange in the supplemental bundle, if you kindly go to page 179. page 150, so bottom left corner. And it starts, you have to, sorry, page 150, I'm sorry. And it starts, you have to sort of track it through. So question at line 3, so I'm on page 150 internal of SB 179. Let's check 1 point first. You've heard Mrs. Stannard say, of course, she was giving you at least part of the account, correct? I heard that, yes, that's right, isn't it? No, it's not. No, that was Nicholas's account to me on a day. It sticks very clearly in my mind. Question, which I won't read out, you see all of that. Answer, yes, she was present. I wouldn't speak to a child who hadn't without being present. Question, you've told me you refreshed your memory when you wrote your witness statement from instant logs, so the evidence you're giving now, PC Giles, is not some pure recall, but something you've come to looking at your instant log, isn't it? This is I couldn't remember exactly what I said. That's why I had to refresh my memory from the notes, but I do remember it was Nicholas's account and not his mother's. I would be very careful speaking to a witness, etc. So there we have a police officer, 2015, takes a note, 2021 in trial, multiple road traffic accidents in between on a daily basis, as he describes. He's saying, I said it must be true.
That's all they can ever say, isn't it? I mean, when I was a trial judge, if a police officer, particularly a traffic specialist who, as you say, must do dozens of accidents every year, if he had said anything other than, if I wrote it down, it must be true, I wouldn't have believed a word he said. How could he?
My Lord, it's not so much how could he, because that's why he's fairly bound to. That's why his having none of it doesn't really take the court further forward. That's why what takes the court further forward is, one, recognising the circumstances. The circumstance, if it's signed, as many of these are, signed, you often get a box. We haven't seen in this case at all. We didn't fill in an ordinary accident report, collision report, pro forma document, in which there is an opportunity that's frequently taken for the witnesses, including claimant defendant, to sign there and then in the aftermath of the accident. If they sign it, one understands it, and sometimes we get, oh, well, it's still an incomplete picture, but you start with a signature. This is very short form, taken, as we can see, from an 11-year-old child who's traumatised at the time. Is it so surprising in those circumstances that PC Gent comes to court and says, as a professional witness, of course that's my evidence? See the observation of the Lord of Justice being, it's not surprising at all. So where does it take the court? When you then reflect upon that against the quality of the evidence that Nicholas is known to have given in November 2015, which is not addressed at all. Not addressed at all, that he gave that evidence entirely. It's a submission, forgive me for rehearsing time and time again, he, the learned judge, has not recognised at all the force and quality of that evidence. As I say, it's quite the opposite, because then saying, well, I'm going to rely on PC Giles, he then flips it the other way round and says, therefore there's an inconsistent second statement and I disregard it. And that goes back to the nugget of the complaint, on which plainly this court would have to form its own view. It's 4:15. I'm grateful for being given nearly half an hour to make my reply submissions, unless I can assist further. Those are our submissions.
As with Mr. O'Sullivan, if there's anything that you think that you would have said if I'd given you a few more minutes, that you have
I'm very grateful.
concluded your response.
I have, thank you.
Thank you very much indeed, Mr. Weir. We're obviously going to reserve judgment. We must obviously consider with care all of the arguments and also to look at some of the evidence again. We will hand down a draft as soon as we can in the usual form. You will all know that it's an opportunity to correct English rather than to have a go again at reasoning or further argument. Can I thank you all, please, for the skeleton arguments that were extremely helpful in reading in to the bundles that we do have, and also to say that you both obviously dealt with the challenges with good grace.
May, can I say before you rise, would you be assisted if we could try and get you a copy of the video in a watchable format? Because if you couldn't open the link, I'm just thinking if
I've got it. I'll extend the offer in open court to my lady or my ladies plural to come and watch it on my laptop if they want to.
well, I
I'll
can't lend
take
you
that
my iPad, I'm
opportunity.
afraid.
It was very useful to see. Thank you.
Thank you very much, Mary.
But thank you all.
Thank you. Thank you, Mary. You want it?